Welcome back, everyone, to the Committee on General and Housing, and it's Thursday, February 12. And we're now with our Legislative Council considering 772 and a total of 5 bills before us. And there's a couple of other bills that are floating around in other committees, and those committees are but we're looking at those bills as well. And what we're doing is we're in the process of sort of looking at these bills from a high level and trying to see where we have committee discussion and also instructions to council of markup of the next draft. So to remind where we were, one of the issues where we were, council, and I talked to you when we were later. One of the things that was hard for us to figure out was the whole situation of writ of possession and then writ of possession on the one hand. What is the exact timing of the process after if the landlord has won the case? What is the exact timing? And the wording was such. And then the second issue is, okay, so what's the exact timing from the moment that the judgment and writ happens to the moment when the sheriff is empowered at least to go and remove the tenant? Right. And then the second issue was, how long does the landlord have before they can get the tenant's stuff out if the tenant doesn't remove it? Right. And what we decided was we really couldn't look at those two separately. We couldn't make up our mind how we felt about the latter until we knew what happened with the former. And we couldn't tell for sure. The issues that came up that was what runs once you get the judgment and writ from the court. Our impression is from the language that has to serve. And it's 14 days, later than 14 days doesn't apply. It just has to be served, presumably quickly. And then after that service, that the 14 days runs, but we wish you'd go over it.
Yeah,
with us.
Yeah, happy to jump in. For the record, Cameron Wood, Office of Legislative Counsel. So I pulled up 2 relevant statutory sections to kind of discuss. Still also have this side by side. The one that's blue is the one that deals with the ejectment process. So as we talked last time, you all recall you have the termination period. You may zoom in.
Yeah.
Okay, so you have the termination period, which is what would start the whole process, and then you have the termination period depending on what you're terminating the agreement for, and all that means is it's notice to the individual that you're terminating. They need to vacate, they stay, then you have to bring the ejectment action. Now this is we're all the way to the end of the ejectment, which, as we talked last time, could take the advocates have argued to you that it could take up to 6 months. I don't practice in that area, so I can't give you any personal experience. But when there is a judgment issued for the plaintiff that they are entitled to possession of the premises, so the judge is saying you've complied with the termination notice requirements and the reasoning you're doing the termination is sufficient for what you're arguing. Non-payment of rent, demonstrated the person isn't paying rent, so we're going to give you a judgment. And then what it says is focus here on the last bit of this section. It states that the writ shall direct the sheriff to serve the writ upon the defendant. There's no time frame there. So presumably the sheriff gets it and is going to go out and serve it, but as far as whether it's that day, they receive it on a Friday, they wait till a Monday, they receive it on a day, They don't have a deputy to go out and deliver it. You know, there's no statutory time frame there, so I can't tell you that it's gonna be that day, it's gonna be the next day, it could be a week. I don't know. That's a question for someone else to answer, but then it is not earlier than 14 days after it's served to put the plaintiff in possession. So you have a minimum there of 14 days before the plaintiff is actually going to take possession.
And just a
Now-
quick question.
Yeah.
Is there some, to your knowledge, any legal reason, either constitutional or statutory, that we rely on the sheriff to do the service? In most civil litigation, the parties do the service, so that the service could be done by the landlord.
I'm not aware of a legal reason. I can understand practically why you may want the sheriff to do it in the event you have to,
Deal
in the event you need to get to a
Yeah.
point of locking the person out or ejecting them, et cetera. But I don't know, I'm not aware of a legal reason why you can't do it of some other party other than the sheriff, other than the statute says. the
But
sheriff.
in the prior parts of the case, isn't service, every time service happens, it's by the parties, right?
Correct, like you don't, the sheriff isn't required to deliver the termination notice.
Or
The sheriff
to,
isn't
yeah.
required to deliver the complaint.
So if we wanted to give the option to tenants, to landlords to serve it themselves, the reason I'm saying it is I have just heard that sheriffs are way overburdened, and sometimes it takes a long time for sheriffs to do anything.
Right, so I think what you're asking is, can a landlord do it themselves if they want to?
Not under,
Not under current
statutory
statute, they
language,
cannot.
no. But
Only
I'm
a
not aware
sheriff
of-
can.
I'm not aware of. a
And
legal-
you're asking if we might want to allow that as an option. A may, not a shall.
yeah, oh, sure, just an option. Yeah, yeah.
I don't think that that's dangerous in putting the landlord in that
Well, then
situation.
they wouldn't do it. Don't you think they're the ones that should make that decision?
I think when things are heightened and volatile like that, they're not thinking clearly. And I think that cops will be called, and I think it just complicates things more.
You, Debbie, do you agree?
Mhm.
Well, no, I'm just gonna say that when you have the sheriff serve the writ of possession. And we pay to have the sheriff serve it. And then he will, what happens in those 14 days, he will visit the people every day.
For the 14 days.
She's saying
This is-
during
During those 14 days.
14-day
Like,
period.
if you take your writ of possession, you take it to the sheriff's office, they have to process it.
Right,
They do their stuff. And then it's given to the sheriff that's gonna serve it. And then what happens in those 14 days, the sheriff will visit the defendant and let them know, on this day, I will be back, and if you're still here, I'm gonna physically remove you from the premises. That's what
right,
happens.
right. I'm just raising the issue of, because I know sometimes you can't even get the thing served because sheriffs are so busy. So it might take, have your experience that, I'm not talking, I'm just that, once you win the serving the writ, have you had any problem with the sheriff delaying service?
We personally, we have not, but I'm
Okay.
sure it does happen in some counties.
Right, right, and you're worried maybe we shouldn't just even allow it because, okay, all right, so go on, I'm sorry to interrupt.
That's just.
All right,
Opinion.
well,
So
we
the
gotta make
latter
up our
half,
mind, you know.
the latter half of what we were just talking about, Mr. Chair, that you started us with, so you have this section, so 14 days have passed, the individual's still there, the sheriff can come back and physically remove the person, change the locks, etc. At that point, for argument's sake, let's just assume that the individual's possessions remain. They have not removed their possessions from the property. What then? So then you need to go to this section, section 4854A, which states that a landlord may dispose of the personal property remaining in the dwelling unit without notice or liability to the tenant or owner of the personal property 15 days after the writ of possession is served, or upon the landlord being legally restored to possession of the dwelling, whichever is later. So you've got the writ's issued, the sheriff delivers it, let's say the same day. The person still has 14 days to remove all of their belongings before the sheriff comes back and physically removes them.
Mm.
So you've got 14 days. Now the sheriff removes them and they've left some property. The landlord is required to keep that property for another 15
Okay.
days.
Oh,
So
I
it's
see.
30 total almost.
I thought it was one extra day.
Yeah, well, it says
Or-
whichever is later.
Or upon the landlord being legally restored, whichever is later.
Mm. And this is right now.
Right
This is
now.
current statute.
So, yeah, this is what I found out. And I thought all would want to know. It's a weird thing
Mhm.
that it's written this way because it says the law elsewhere says when the writ of possession is served, you can't get possession sooner than 14 days after that. This acts as if you could.
So if
Maybe they
somebody's-
leave, they just
Yeah,
leave
that's-
voluntarily. I
And
see,
this is
yes.
after a court proceeding not being served.
No,
No.
no, what happens is, A, you win.
Yeah.
When you win, you get a judgment. The
Right.
judgment is a writ of possession all in one. Okay, then the sheriff has to go out and serve it. Whenever they serve it, day 3, day 5, whenever they get around to it, 14 days has to run before the sheriff can go back and remove them. Then there's another
Right.
15 days before they can take their
No, I
stuff
get
out.
that, but what I'm saying is, I know an experience where the landlord sent the sheriff letter to the tenant, but then they went to court because they were arguing against the eviction. And the person remained in the house for months during the court proceeding, is my point.
So this is all after that.
That's what I was
That could
asking.
happen,
So
yes,
after
yes.
the court decision, then this clock comes in. You can't remove the stuff before that happens, is what I'm saying.
Right.
Got it.
So it's a total of 29 days
After the court decision.
Yeah.
Because it could be months in
after the
court.
service of the court.
Right.
Yes.
The way I'm reading it, it's saying
Bless you.
15 days after writ of possession is served, so that's the actual sheriff showing up to the tenant and saying, you now have 14 days.
Right.
After that 14th day, the 15th day, since that action, we get to take your stuff out. But or upon the landlord being legally restored to possession, that's the decision, that's the court decision.
So the court
The
decision is the
landlord
writ.
being, no, that is the serving. The writ of possession is served. Isn't that the actual sheriff serving?
Right.
Yeah, and then the landlord being legally restored to possession, wouldn't that be the court decision? Wouldn't that be the judge's decision?
It's the 14-day period after. So if you go back to the previous section. The writ is directed to the sheriff to serve it and not earlier than 14 days, put the plaintiff into possession. The plaintiff doesn't get possession
Until
until the
14
person
days.
leaves or until the sheriff removes the person.
So
So
go
the
back
writ
to go
is
back
saying
to
that you have a legal right to the possession, but then your physical possession of it isn't gonna occur until here.
could you go back to the other one? Because I think she's being a great lawyer here. She really is. God, you guys, I mean, come on. She's making the argument, which I think you're saying, no, it's not that way. She's making the argument that as a matter of law, quote, the landlord is, quote, legally
Restored to
restored to
possession.
possession
By the
when that,
judge.
by the writ, by the judge. And he's saying they're legally entitled to possession, but they are not, quote, restored to possession until they're physically, the tenant's out.
I think it's an amazing question and interpretation. I think you have to read it the way that I'm reading it, because if you don't, then the person is served, which is always going to happen after the writ is issued.
Yeah,
And then the person is served, now the individual can remove all the property. And so if you read it that way, the 14-day period in the previous section doesn't have any effect. Do you
And
follow what I'm
also,
saying?
if you go to the previous section, look at the word restored to possession, okay? In this one, and then go to the prior one. And not earlier than 14 days after the writ is served, put the plaintiff into possession.
But that
In other
still
words,
says,
possession is
served.
different than right.
But that still says writ is served.
The writ after 15 days after a writ of possession is served. Service is one thing. Then 14, or upon the landlord being legally restored to possession. And when what he's saying is, and I agree, restored to possession doesn't mean legally entitled to possession. It means restored, which means the tenant is out and the landlord is free to re-rent. So
agree
I think
with
it's
you.
poorly written. I think they
It is
meant,
terribly
I think they
written.
meant what I
You're
said.
saying.
I think they meant what I'm saying.
And they just wrote it wrong.
They did.
Who
Yeah.
wrote this?
I think
Okay.
this goes all the way back.
Yeah, why would they have written the second sentence if it means that, if it means?
So if you have to go with the latter, what's the whole point of the second?
Well, because again, they could
They couldn't
happen
leave
on the
early.
same day.
Yeah, in other words,
Then why would you say that if it's the same thing?
in other words, if you go to the, let's say the landlord,
Fired up.
the writ is served and the tenant goes, oh God, and they leave after 4 days or they leave after 5 days. Well, then at that point, the landlord's entitled to possession and the 14
No,
days.
it's not,
right there.
because it says it would have to be after court. It's gotta be the later of the two.
Right,
It has to be, no matter if the person left on the fourth day after being served. It's after that, so it's still the same period of time
it
in that
says
period.
the later, go back to
In that
that language, it
scenario.
says the later, whichever is later. 15 days after the writ, no, you were where you were. 15 days after the writ of possession is served. Right? Or, I see what you're saying, no matter what, you'd have to wait.
Yeah.
So why
Okay.
would you need the second sentence unless you're clarifying that
You
the
are being,
maximum is
yes, you
15
are showing
days?
how badly written it is, yes. But I
Then why
think,
needs to
No,
change?
no,
Yes.
I'm saying that it's
Um,
been poorly interpreted. I think it's written the right way. It's just that it should be interpreted as meaning it's
Okay.
15 days
Well, you
from
know
the
what?
decision of
let's
the,
just ask
or
me,
the
let's
decision
ask
of the
Nadine when
writ.
she comes in here, what she thinks.
If the court has decided, but the sheriff has not been able to show up,
So, but I
You
think
have this
can't
maximum time.
read it that way.
Yeah.
Because if you read it that way, then you are significantly reducing
yeah,
the obligation of the landlord to maintain the property. If you're reading it the way that you're interpreting.
Why is that?
If you're reading this legally restored to be the date the writ is issued,
Mhm.
then
You could leave the
it's not
courthouse to
necessary
take
to
their
be
stuff.
there, first off, because the date will always be after the day it's served. If it's the day the court issues it or the day it's served, whichever is later, it will always be the day that it's served, which means that this sentence means nothing, which based on your statutory construction, it can't be the case that it means.
Okay, in any case, ladies and gentlemen, might I argue that we should move on to what we would like it to say?
Yep.
Rather than what it
Yeah.
does say?
Oh, we get to rewrite it?
Exactly.
Oh, nice.
I think that's.
I mean, let's agree that there is a credible argument, which I would go further than that. That there is a credible argument that we are talking about 29 days passing before you can take stuff out. Okay,
Yeah, that's credible.
Can I just say real life?
Yeah.
We just got one for 7 days. Not 14 days, which you say is the law today. The judge gave 7 days.
7 days for what?
They gave in 7 days, instead of saying 14 days, it was 7 days.
What?
The writ of possession.
Okay.
That's interesting.
So the court can interpret it how they want.
Not legally, they just do it.
but apparently it doesn't matter because it has to be whatever the later date is, so
Yeah,
it's
yeah.
still.
Yeah, Tom.
Okay,
So they have a case that the
I think it
7
would be
doesn't
worth
really apply.
asking the sheriff how they've been reading this. Now, it may be consistent, it may not, but secondly, I can only comment as to how I observe this being applied, which is, in the instance I'm thinking of, the judgment is made, the writ is served whenever they get there and serve the writ. That starts the clock, the official paper. And It doesn't say they have to serve the writ 14 days later. It says
No.
they serve the writ. 14 days later, they come in, the tenant is removed and the locks are changed.
Right.
The next day, they clean out the apartment.
Look at the next language. But first, look at this.
Yep.
When is, go back for a minute. What is the word that is the key word of that sentence? Serve the writ, that's one thing. A, B, after 14 days, the writ is served, put the plaintiff into keyword possession.
Yeah.
Okay, look at the next section.
Mhm.
Okay, 15 days after the writ of possession, forget that because it's whichever is later. Or upon the landlord being legally restored to possession. Okay? So 15 days after the landlord is legally restored to possession. That doesn't happen until 14 days. So it's 14 plus 15.
No, it's 15 days after it's served.
No,
Whichever is later.
as your attorney, I'm telling you.
Yes.
Can we pretend none of this language exists?
Yes, he certainly can.
And then
And then maybe.
come up with what we want it to be.
What do we want?
And have it.
That's what,
Much
stop
better
talking
written.
about the status quo and ask what we want.
I am in favor of 14 days after that paper is served. It's out, done.
They're out and can they take the stuff out too?
Yes,
I say one day.
same day.
One day it's.
After the sheriff.
No, I
But
mean
they've got-
14.
Oh, yeah, but there's 2 weeks here and I don't know that I would go shorter than 2 weeks because, yeah, people have jobs, there's all kinds of things going on, but it's not, I can't see how this would be a surprise anyways.
So 688,
So-
so you do have a question, but 688 proposes that, which is
That's.
immediately after the individual is given possession, physical possession is essentially how it reads, but
772 also.
physical possession, then the landlord can remove the property at that point.
I'm not.
But these
I-
are all calendar days, correct?
Yes.
Is possession the same as ownership?
No,
No,
possession
already
means
the owner.
physical possession.
I just have it, but I don't own this.
As soon as you get the judgment, well, first of all, you always own it.
Yeah.
The question is, does the lease, do they have any right to be there? When the judgment's issued, the right goes away.
The stuff that's in the unit.
Yeah.
I possess it.
The unit,
The
right?
unit, not the stuff in
No,
it.
the stuff
stuff.
in the unit.
You don't possess that either. That belongs to the tenant.
You're just getting rid of liability for throwing it away.
What are you
You just don't
concerned
get in
with?
trouble for throwing it away. That's it. You
Anything
don't own it,
that's
you don't
not
possess
nailed
it,
down.
Anything, you just can't get in trouble for throwing it away.
Yeah, that's what this is establishing.
Well, I'm not comfortable with
It's, I just.
And I think,
that sped up.
Well,
Getting rid of stuff
Okay,
like that.
so just to clarify, and then let's get to what we want.
Possessing.
feel free to raise that because it's a area of the law that I'm not.
Clarify. We said, just so you know, our attorney informs us that after the writ of possession is served, a total of 29 days, 14 days elapse before the tenant can be thrown out. And then another 15 days goes by before the landlord can take the stuff and get rid of it. 688 and 772 both basically eliminate that extra 15 days. They basically say 772 says immediately after the landlord is quote legally restored to possession. end quote. And 688, it says immediately after the writ of possession is served. So just to clarify that. Also, going back to the first period, the first 14-day period between the time of service and the time that you can be thrown out. Currently, it's 14 days. 688 says 24 hours. 772 says 7 days. So, ladies and gentlemen, how much time do you want to allow? A, between the time it's served and the time that they can be removed from the premises? And B, after that, how much time do you want to allow before the tenant stuff can be removed if they don't remove it themselves? Yes,
Is there any way that we can find out how long it takes for the sheriff to serve?
it depends on the sheriff.
And you can't give them a definitive date either. Like, you can't put that in statute, like must be, I mean, you can do what you want, but they will not, that will not go over well if you say must do it within, they can't, what I've learned from being in judiciary so much this year is they can't, how can they prioritize, like, if there's like a domestic violence situation or like a murder where they're then, oh,
They
but
need
we
to have
have to go do
discretion.
that, right? They
Yeah,
need to decide,
discretion.
triage, like, oh, we can't just, then, oh, but we have to do this tenant thing, you know? So like with my animal welfare bill, like the judge and courts and people like that, they didn't want to be told you have to do this if there's something else that they might need to do.
They do work only weekdays. They
Yeah.
don't work weekends.
Right. Well, that's why I
anyway,
suggested
I was
maybe
just
let
saying
the
we-
landlord do it.
That's good.
We can't give them a,
Right, so they have this, it depends on this, there's sheriffs in every, it depends.
probably get a different answer from
Okay.
everyone.
So you said they only work weekends?
No, they only work
Weekdays.
weekdays.
Oh.
Weekdays.
Yeah, I mean,
They
no
don't work on
weekends.
weekends.
Why would they?
There's no
I mean, our
time on-
sheriffs could be doing 4 evictions a day.
What?
Okay,
Everyone
ladies and
needs a break.
gentlemen, how much time do
Okay,
you
well, I
feel?
would like to say that I have heard from tenants. I see both sides of this issue, but I have also heard from tenants of what it's like to have everything that you have disappear and have no place for it to go. And we talk about what's fair and not fair, and I get that landlords have those rights as the owners, but I want to be conscious that,
Yeah, so what do
Sometimes-
you suggest? What are the days that?
well, I hadn't gotten there yet.
Okay,
I was just
yeah,
formulating my,
Yeah, your
yeah,
thoughts.
sorry,
that I,
sorry.
no, I'm thinking, I'm not, I wish I was like, that's not how I roll, but I just want the committee to know that I feel that, again, and I'm not in charge, that
Nobody's
just-
in charge.
let's be aware that it can be really hard and damaging. Same with when you slash tents, and then where does those, I make sure that Public Works takes people, stuff. People's stuff is sometimes everything they have. So I just want to be aware of that,
Okay, so,
but I don't have imagination, maybe
Right.
Joe has another.
okay,
I have a number, I'll put it out there.
okay,
People can say it's terrible or
no,
whatever they'd like.
somebody's gotta start.
Yeah,
Yes.
yeah, yeah. So both bill, one has it immediately, one has it 7 days. And then after 7 days?
Yeah, that's after after,
One has it fine.
yeah, no, wait, Joe, which time period are you talking? Think 2 time periods.
Yes,
You're
the
talking about,
judgment to, you have to be out.
leave me out, okay, it's 14 current, 688, 24 hours, 772, 7 days.
Okay,
7, 6.
this is fine. I would propose the 7 days with a 72 hours after that your stuff has.
And I would propose 10.
Because I think in my thought process of that, of having a longer runway after you've left, I think for a lot of people, that is the catalyst. I think when you give somebody 10 days, you're gonna have somebody take 10 days. When you give them 9 days, you're gonna have them take 9 days. But when you're out of your unit, that's your reality of like, oh crap.
So you're
Now you
saying,
have 3 days.
you're saying 7 to be removed,
Yeah.
plus
Alright.
3 to get your stuff out, for a total of, as your stuff, 10 days.
It'd be 10 days.
Okay,
Because the whole, I mean, you're not kicking the tenant out because of their stuff unless they're, hoarders having a problem with that. I get it. But like a lot of the times you're getting rid of that tenant for other reasons. And in that case, that tenant is now gone. It's just their stuff.
Nora and then,
I wanna make sure, are we still considering having that alternate scenario that there has not been a service of the writ? Like, so you're saying that the language, in the end, we concluded that the language is not talking about regardless of whether the sheriff has or has not visited. Like, there's no time clock starting at the point of the court decision.
Right.
Should we have that?
What she's saying
Regardless
is
of whether the sheriff shows up or not, or do you, like, because right now,
you can't, I think constitutionally, you can't deprive people of property without notice, and
Yeah.
that means service. The question is, and just
and we
just
can't pressure,
focusing.
and we can't pressure the
Right,
sheriffs
and
by
I
adding,
threw out the
yeah. I
possibility
was just trying
that
to-
if the sheriff was unduly delaying, that service could be accomplished by the landlord. And Debbie was saying she's not comfortable with
Yeah,
that
that
because
makes sense.
she feels that's quite likely to provoke some violence.
Yeah,
In other words, if you're really talking about taking people out of their home. So Joe is proposing service
service.
Seven.
plus 7
plus
days.
7 days.
After
and then
7 days and they're out, 3 days.
3 days.
Right,
I
Joe?
think it was.
Yeah,
Debbie
and I think, I mean, that gives you
Sadia.
weekends, right? That gives you the weekend that they could possibly be longer before they're served. I just think it's a fair.
Okay.
If it goes to the sheriff removing them from the premises, then the door, they put a no trespass sign on the door.
Yeah.
The locks are changed. And then we, as the landlord, would have to take all those possessions, load it up, and take it to storage. 3
Well,
days.
couldn't you, my impression is you could always just, the tenant would have to call you and get their stuff out. In other words, they'd have to arrange to get their stuff out.
Right.
You wouldn't have to, for 3 days, you wouldn't have to put it in storage. The tenant would have to arrange with you to get their stuff.
Well, they can't go back in the apartment.
But wouldn't
But
you,
you-
if they called you and said, can I go back in and take my stuff out, would you let them?
No,
Why not?
because we wouldn't do that.
Because you're afraid that they then would stay.
Right. And then what are you gonna do? Go through the whole process again? They refuse to leave?
Well, you'd have to-
This
Trespass?
is not equitable.
But you have to remove all their stuff, put it in storage.
There's a
For
question.
what is being proposed.
Which is now the case, correct?
Right, we have to do that and we
That's
keep it
what's
for
gonna happen.
15 days, then we can throw it out.
Well, then this just
Throw
makes
it
me think that
out.
we have to make it match up, that it has to be like you're out with your stuff.
Sadia has her hand up.
And you
Saudia,
give you more
sorry.
time.
Thank you.
That's fine. Thank you. Yeah, I'm just,
Joe agrees.
I'm
Sorry, Sal.
no, you're good. You're good. I'm just trying to ascertain like what is the intended outcome here? Because we know what the barriers are. And it sounds like we're like in the same situation we were in yesterday where we keep going in circles. And I'm confused as well. One, I'll just say this: the part of saying the landlord may, I mean, I would say yes, because if landlords are complaining that the sheriffs are taking too long, then give them the option, not saying they must or shall, but they may, if they so choose, at their own discernment, knowing what situation they are in. And hopefully they'll be, knowledgeable enough to figure that out and know what they're dealing with and what their level of safety is, right? So it's not saying they must, it's saying they may. It's another tool in the toolbox. I feel like what we're trying to do here is give resources, is what we should be doing. And so that one, I'm actually fine with saying they may, in the event that the sheriff is taking too long. Otherwise, they'll be waiting until who knows when for the sheriff to show up. So options are wonderful. Love options, great. When it comes to the writ, I'm going to say the same thing I said yesterday, in that, or 2 days ago, in that it's just, from the time that people get out or have the notice, I feel like our role here is to set the precedent of what the statute and policy should be. And it needs to be a reasonable time. And I think the time frame currently is reasonable, the 14 days. If it is in fact 14 days, even though we just heard it's what, 20 after you add up all the times. So I say the however you word it and however you get to the 14, after the notice is in the tenant's hands, I think 14 days is a reasonable amount of time to
Agreed.
have them remove their property
Themselves
and
and their
themselves.
property.
and them.
Yeah, just make it line up.
I just where I find the challenge is we need the language is what we're looking for, the language to make this enforceable. I think that is the barrier. And so I think that is where the conversation should be on how do we enforce what we're trying to accomplish here, as opposed to continuously going back and forth and not getting where we're trying. We're not going to get anywhere at this point is what I'm saying, if that makes sense.
Okay, Mary.
A couple things. One, my own personal opinion, I would think that a tenant who's being evicted would really take it serious if a sheriff showed up rather than, and gave him the paperwork, rather than the landlord could just, he could just blow it off, and that could create a real serious problem between the landlord and the tenant. But what I would like to ask Debbie is, what is your experience with people that you may have evicted? What was their time, and did they get their stuff out? Or
We had one that was 14 days. And the sheriff visits them every day, the same one that serves the writ, visits, lets them know what day I'm coming, what's gonna happen, he'll let them know what time is gonna be there, what's gonna happen. And what happened was, in those 14 days, they brought in animals, they brought in drugs. There was drug activity going on, and still they had to be physically removed. I mean, the sheriff, we're there, the sheriff goes, you wait in your car and we'll handle this. And if they have to handcuff, they physically remove, you can walk out willingly or whatever. And they don't get their stuff.
What do you mean by
They
Take their
never
stuff?
get their stuff.
or they never came back to get it?
Is that
Well,
one
we
case?
had to move it to a storage place and they never pick it up.
I mean, that's one story. I can tell you another story about a single mother. I understand. I'm saying there's not going to be consensus in this committee on this issue.
Right.
That's clear. But we can talk about stories all we want, but we have to make decisions. But
Yeah.
this is not going to be an agreed upon thing.
Well, I think it would be great if we could reach a compromise. The current situation is 14 plus 15. And can we do better? And what I'm hearing, I'm going to put this on the table. I'm hearing, first of all, I mean, one option that people seem to like, although it's a little long for Joe, is 14 plus 0. Right?
I could compromise.
I think
that.
Joe,
So,
yeah,
14 plus 0. In other words, you have 14
speak for me.
days, and then at the end, 14 days, and then your stuff is.
your
so
stuff
then-
and yourself.
And you.
And
So
yourself.
like if, so that you don't have, I mean, I think this is something that the landlords would benefit of, like not having to move the stuff, store it. And you don't have the liability over those things.
Do you have to do that
And-
anyway? Go ahead. I'm sorry.
And then, but we guarantee that the person has 2 weeks from the time that the sheriff shows up
Right, in other
to
words,
do both the move
okay.
and get out.
Yes, no, I mean, excuse me.
I agree, Emily, that there's going to be so many different scenarios. However, when you're behind in rent or if your behavior is off, this is not happening in 14 days. They are very well aware and landlords have discussions, so that 14 days is just making it fair for the tenant. You have 14 days to get out and also get your stuff out, and it's also fair to the landlord.
I'm not against the
No,
14.
she's saying 14+0 is okay.
Oh, okay.
I'm saying, I'm not trying to be, but it seems like is possibly someone on our committee who wants it quicker than that.
No, what, I'm gonna just try to frame this. I think we're coalescing around this, but there's two different issues.
You're
Under
saying-
0, I think that's better than existing law, and that's a good thing. The 14 days, you're saying, when you hear this tenant stories about not having, trying to get their life together in those 2 weeks. We're hearing on one side, that's reasonable, that's okay. Debbie's saying, no, it's too long. And I think that,
And that's my floor,
yeah,
and that's
no,
fine.
No. But listen, just because we have disagreements doesn't
Right.
mean we can't coalesce around an issue. The
Right.
question everybody has to face when it comes back as a whole, can they support it?
Right.
It's, in other words, if I say, okay, to council, please draft it at 14+0, and will you clarify that goddamn language so that it does not, it satisfy us? You're gonna get, then it'll come back that way and people can decide whether they want to vote for it. My one question for you, Debbie, is under existing law, do you always move property to a storage unit? Just because you can't, there's no other way to get rid of it fast.
Well, because we don't own it yet, so we have to store it.
Why don't you own it? Because of the 15 days. What
Right,
do you do at the end of 15 days?
we have a 30-yard dumpster.
Or you have a dumpster come and get it. So under this provision, you could have the dumpster, it's like your bill. You could have the dumpster come at the end of 14 days. You could have the dumpster waiting when the tenant is removed.
I just want to say,
Would you?
I do, well, I'm just saying I have, our sheriff will come on Zoom and explain the whole process. He can explain the TAC orders and he can explain writ of possession, what all that means.
Okay, good. What I would like is, I just want to know if this is okay. I'd like council to redraft it, clarifying the language as pointed out, to remove the ambiguities pointed out by the other attorney in our group, and to draft it as 14, believe it's not the only time. Anyway, and draft it at 14+0, and that we should get an offer, if we can find a sheriff to walk us through, we can do that.
I'm sure if you have time, is there time?
Well, we're not, I think there may be time next week, yes. Okay, so those two issues,
You might want to reach out to the Sheriff's Association to have like a more broad.
Yes.
Than individual sheriffs.
Right. Yeah, and whether this is something they want to deal with
I'd rather hear from than.
yeah.
as an individual.
Okay,
sheriff.
yeah, that's good,
Correct.
yeah, all right, that's good.
Yeah.
The office of sheriff.
Yeah. Let's see. Cameron, I'm just trying to think where you don't have instructions.
So
Okay, I wanna, I wanna,
Can I just add
Yeah.
one thing? Can there, would it make sense to also, if we're shortening that, like legal, like this is your writ, is there reason to think that it might be helpful to have something like that somebody has to tell before the sheriff shows up even, that as soon as the decision's been made, that there's another way aside from a sheriff, serving somebody, that there should be a way to inform
Well, first of
that
all.
this is coming.
Yeah, this has happened. That's why, when the judgment is issued by the court, it must be served.
No, I get that, but that's a very formal service that requires staffing, availability.
Yeah, there's other ways to do it.
Scheduling, and that realistically, if we don't want to end up with a bunch of extra pain and wastefulness. Because realistically, if I tried to get a moving van the same weekend that like, if I was served on a Friday, there's no way I'm getting my stuff out that weekend, and I may not even be able,
But
you
you
know what
don't
I
have to,
mean?
you have 14 days.
I have 14 days, which is 2 weekends.
I think she's saying a shorter time, it would be too short.
Said
Yeah, shorter
14.
would be too short, but if there's a way to
Give them notice.
give them, yeah, just give notice without us serving.
Oh,
Like,
yeah,
you're gonna
you
be
can do
served.
that.
You're gonna be
Landlords do that
served
all the
soon.
time.
Yeah,
Email, phone call.
but can we put that, just like the notice that we've defined notice without it being a service? Can we put something into the language that says that the court has to notify?
I think that's what that. the
And
far
you would
end.
think that it would be obvious, I would
Right,
suppose, but
Right.
but somehow we're getting so hung up on this because it seems like we're talking about 14 days. But does it, not if the complaint is, no, this is
Right.
longer than you think, because it's not just the 14 days, it's 14 days from when the sheriff deems it, has the availability.
To
show up.
About that,
Ask her what?
about what the different options and what people present, how they present. Do you see what I'm saying?
Yeah.
Like, let's see what landlords are doing now to notify, right?
Yeah.
See what the stat, like what people currently do. Thank you. Obviously,
Um,
because I don't know, I'm not a
I
landlord.
have a question for Debbie. You said that, you have to pay for the sheriff? And does the sheriff, once you speak to the sheriff, then the sheriff, what was it called, the writ?
Serving.
Okay. So in between that time, you said they come every day? And you have to pay for that every day? Just the one time?
But if they have to remove them at the end of whatever time frame that it is, then that's an extra fee.
Tom?
Is it conceivable that a judgment would be made in favor of either party, and that if they're not there in the courtroom, that their counsel doesn't advise them the same day of what the decision was? I mean, are we trying to solve a problem that doesn't exist?
It exists when people aren't represented.
Okay,
And also the courts don't notify anybody of anything the party, they're required to.
that makes sense.
Yes, so if nobody's represented, I actually don't know what happens if it's both people are in pro per.
All right.
And if then usually they're in court, yeah.
Right,
Yeah.
lawyer to lawyer too is a thing.
Lawyer to lawyer, oh yeah, then it's right away.
I don't have much experience in this, but it's happened 2 times. If they're not in court or represented, the sheriff just shows up. And gives
Yeah,
them-
if they, so there's a couple of possibilities. One is a situation which probably is not uncommon, it's not a majority, but it's a lot. When the tenant never shows up in any way. That is, they know I don't have any money. Or they know I hate the landlord and this is awful, I'm out of here. I had a case like that. And they just they don't bother going to court, they just wait it out until as long as they can. And usually that's until the sheriff comes out with the writ and says, I'll be back in 2 weeks and you're out.
Mhm.
Then they make alternative arrangements. But so that can happen. Or they're unrepresented and they don't know to come into court afterwards, or they answer And then the court says, well, okay, I'll let you know what I'm gonna do, and then they issue an opinion. I don't know what the court does when both parties are unrepresented. Do you? Yes, Debbie.
I just want to say, I mean, if we even cut it down, let's say, just looking at, let's say, just 3 days. And let's say it turns out the sheriff serves it on a Friday. They don't work on weekends, so it's like Friday, and then so Monday would be the fourth day,
Right.
and they could be removed if we decided 3 days, right?
They could be removed, right?
Or-
People are saying that they'd like to stick with the 14 days.
Yeah.
And then, but no extra 15 days after that.
Yeah.
I stuff, what you told us about midnight movers.
Yeah, that gives them 2 weeks notice. It's
Oh, yeah.
conceivable that's
But
the
I don't
first
know how
notice they're
long they
getting
were
is
packing
that
up,
document,
but
so
you just have to
I
be
would-
Yeah,
there.
the first notice they're getting is the sheriff coming out and saying, I'll be there in 2 weeks. And you and your stuff will have to get out. I'll have to remove you, and the landlord can have your stuff moved to a storage unit.
Well, my
Well,
position
actually,
is that
you
3
know,
days is
always.
way too short a time.
What?
My position is that 3 days is way too short a time.
For between the time of the writ being served and the time that the sheriff can remove them. And how do you feel about 14? How do you?
14 plus 0.
So what I'm hearing is that nobody except my original draft was 7, Debbie's was 3, and I hear Debbie and I are out in the cold on this as far as the committee was concerned, but at least for the next.
Well, you
draft.
still kept the,
With the 15
15,
days.
yeah,
I had another 7, but I can live with definitely 14 and 0.
I think the biggest concern is that like, for Debbie's part, it would be if they were, if you're kicking them out for damaging the unit and then you give them 14 days, you probably haven't seen anything yet,
Mhm.
which that's,
But I could do a lot of damage in 3 also.
I know, I get your point. It's just hard to like tell
Yeah.
somebody.
Okay,
But we just get
5
it back
days.
sooner and
yeah,
start.
right now, okay, I want to raise another,
I get it.
Is it?
we're gonna take, let's see, we've been at it since 10:30. So let's take a break. Well, can we just go to lunch?
Yep.
Okay.
Yeah.
All right, I want to clarify something and ask you how you feel about it. These are, um, I'm just trying to look at my memo and the differences. One of there are some appearances of differences between the options that aren't really differences. In other words, 772 and what is it, Debbie? I keep forgetting the number.
Oh, 688?
688. I mean, basically, 772 just eliminates the words no cause and for cause or just cause. But there's really not a lot of difference in these bills in that all of the Debbie's bill, 772, all allow one, the landlord to terminate the lease. Excuse me, to just non-renew a lease. Landlords are free to non-renew. They're free to sell the unit. They're free to convert it to family use, to a condo, or substantially renovate it. There's no difference there. The question is timeframes and notice period. Biggest difference, which I just want to bring up and see how the committee feels. Neither 688 nor both 688 and 772 allow the landlord to non-renew. 440 and 339 do not. In other words, if a tenant is paying rents, Saudi, I'll get to you. If a tenant is paying rent, there's no termination for lease end after a probationary period. There's a probationary period of 6 months in 440 and 3 months in 399. But after that probationary period, as long as the tenant continues to pay rent and not break the lease in some other way, they are free to stay in the building, period. That is not the case with 772 or 688, 680. Those 772 and 688 continue existing law, which says that if a landlord and a tenant enter into a 12-month lease, that's what it is, 12 months. And it isn't more. Saudia, I'm just raising this issue, asking the committee what their feelings about this is. This is an important difference between these bills.
Yes, thank you. And I just want to clarify, and I'm glad Cameron's in the room to clarify this for me. So a couple of things on 440. Well, one, I have a question.
Oops.
You froze, Sadia. Okay.
I think it's not. I just
No,
trust you
I'm
now.
saying this is what we could write.
We could.
On the 13th
Bring
month.
that back, yeah.
We couldn't hear you. You were frozen.
Oh, okay.
You
can hear me?
froze. You
Sorry.
just said, the furthest you got was, as far as we could hear, was, I have a question about 440 and a comment.
Thank you. Okay, so I said I'm trying to understand the right to non-renew. So if a landlord doesn't renew the lease and the tenant pays the rent on the 13th month and there are no complications, what happens?
Well, it depends on what the landlord wants. The landlord can just say nothing and accept rent, and it turns into a month-to-month rent, which is not uncommon, actually, Saudia. Lots of
No,
times. That's what. But if the landlord says, no, actually, I want you out, well, then you have to leave
Okay.
or be evicted. Yeah.
Okay, thank you. And so if that happens, then they still have to go through the eviction process.
Yes. In other words, let's say you have a 12-month lease.
Right.
And the landlord decides that they don't want you there anymore. And so they refuse to renew. Okay.
Right.
And then you say, well, tough, and you pay rent. First of all, they don't even have to accept it, but also if you pay rent, they can move and give you notice of, notice that termination and then go through the eviction process.
And they still go through the eviction process. Thank you. Okay, so the same thing. So I just wanted to just clarify, and Cameron, you can correct me if I'm wrong, that in 440, the landlord can in fact give a notice before the end of the lease.
So-
Go ahead.
Yep. Sorry, Representative Lamont, just to jump in there, I was gonna clarify, were you asking about current law or 440? Because,
Go ahead.
yeah, because Mr. Chair was describing current law
Uh-huh.
under.
He's asking 440.
Under 440, if there is a lease that is 12 months and then it expires, it would then go into, what is kind of termed a month-to-month lease agreement. However, the individual, once they pass their probation period under 440, they cannot be removed due to the expiration of the agreement or due to the end of a month period coming. They are there and they will remain unless they stop paying rent or unless the landlord can remove them for some other reason that's stated in statute.
Correct. Okay. And then also, did we not state, because I asked you explicitly about this when we were drafting, around if the landlord knows they don't want the tenant to be there and it is month 6 or 7, they can still go through the process and submit notice. And
So-
it would run the course of the time limits that are in the bill. Is that not accurate?
So your 440 has a probationary period of the first 6 months. So the landlord can remove the tenant within the first 6 months by giving 30 days notice.
Right.
Once that 6-month period is up, the only way the landlord would remove the tenant is if the tenant failed to pay rent, if they failed to comply with the material terms of the agreement, if they were conducting criminal activity or threatening other individuals, or for a very limited subset of circumstances, they wanted their immediate family to occupy the space, the place needed renovations, or the tenant refused to accept good faith renewal terms. So in 440, if the 12-month lease expires and the individual goes month to month after that, the landlord wouldn't be able to remove them because there's no agreement. But the landlord could come to the tenant and say, you need to sign a new 12-month lease agreement. And if the tenant refused, then at that point, the landlord could remove them.
But otherwise, if it's just to clarify, because I can see where Saudi is going.
No, you can't wait. No, let me finish my statement. Thank you. So I'll tell you where I'm going. Where I'm going is that if they submit a new lease, the lease is up, and they say, here is a new lease, they can give the tenant a new lease. And if that tenant refuses the new lease, then they can start the eviction process. So my point is, there are ways in which in 440, they're not there indefinitely. There are options. The landlord has remedies. They have tools and resources and recourse available to them in 440. Because trust me, that was a compromise for me. That, my friend, is what you call a compromise. When you say, if I give you a new lease and you refuse it, then I can start the eviction process. That's not saying you can stay there forever indefinitely. So I just want to caution, because the framing of it is that, 440 says you can just live there forever. That is not what it says. What it did was it put in notices and it gave timelines. That was the important part, was to clarify the language, because what happens is, and we heard testimony with people with developmental disabilities and all kinds of learning disorders, and we talked about reading and writing and understanding notice. So when someone is in a contractual long-term agreement and they're paying their rent, they may not know that, hey, at the end of this, especially if they've been in situations historically, like many people are in Vermont, where you pay your rent and you stay beyond that point, it may be amiss to them. So that is why I am suggesting we clarify the language around notices and what people are aware of. And that was the important part for the writ notice, everything. We have to take into accountability people's awareness of the situation, because we have to make sure everyone is on the same page, understanding the same thing. And that's why we have agreements, notices, and options. And that's what I wanted to say. That's where I was going with that. So sorry to cut you off, Chair. But I feel like people weren't articulating what I was trying to articulate, and that was my point.
So I will agree with one point Representative Lamont makes about 440, which is the person would not be there indefinitely. If the landlord was providing a new lease term and the individual didn't want to accept it or refused to accept it, at that point, it would give the landlord an opportunity to remove the individual.
Is it at all clear under 440? If I'm a landlord and I offer a new lease term, but I increase the rent, and they don't take it.
The only thing that 440 would do is there is a section in there that has a maximum increase in rent section. So as long as the new lease term, new 12-month term, rent is being increased and it's in compliance with the maximum rent increase section that's being proposed.
And that's CPI plus
Was
3, I think. Yeah, CPI.
or 8%, whichever is lower.
Right. So the difference, to be clear, just to try to clarify, 772. And 688. Leave current law in effect. And by current law, that means that just simply the lease is what the lease is. And after that, the landlord is free to non-renew. The motivation there, and I can't speak for Debbie's bill, he can, but my motivation, to be clear, was twofold. One, what I've heard, both in actual testimony, but also people talking to me, is that there's a whole subset of reasons why a landlord wants a tenant out that are such that they just don't want to go through the whole eviction process. It's too much. And so the tenant might be being really unpleasant, really difficult, but not violent, or, not, or violating the terms of the lease in a minor way, like smoking. Maybe that's not that minor, but, and they just don't want to go through it. And they just feel like, well, I'll just let the lease run. And that way I won't have to spend $10,000 on attorneys, and just let the lease run. And that was one thing that influenced me in going with the status quo. Another thing that influenced me was, I feel that, I guess I know this is sort of formalistic, I admit. I feel like a contract is a contract, and when you enter into a contract with someone for 12 months, it doesn't mean forever, it means 12 months. And the also, I'm hearing, and I will be talking about it, I'm not comfortable with across the boards. I'm just speaking for myself. Okay, this is what motivated me. My initial research was that there is no state in the union that allows a tenant who is, following their lease and paying rent to stay indefinitely. It's just not to my knowledge. I imagine, maybe, I don't know what the cities require. Perhaps New York City has provisions that I'm unaware of. And I just didn't think that a bill that would made us an outlier like that would get through. So as a matter of compromise, I didn't put it in. I really appreciate that Saudia's bill is a compromise in many ways, especially compared to 399. But, and then finally, well, I guess those are the reasons that I stayed with it. I think that the big difference is the approach in 440 is, it does depend on rent control, obviously, because otherwise the landlord could just raise the rent, but is that it just basically takes the point of view that a tenant who is complying with the lease in good faith and is paying rent should be able to stay indefinitely, because it's housing, and housing, if you believe, as many do, is a fundamental right, they should be able to stay. And then the other view, it's really unfortunately difficult. And the other view is, yes, but housing is a business, and if you enter into a contract for a period, it should just be that period. And if you're not happy with the tenant, you shouldn't be stuck with them. In a way, those are sort of irreconcilable. They're just, I'm admitting it's not as if any of them is silly, right? These are not silly differences. So I'm curious, what is the sense of the committee on this issue? Because
Well, I appreciate, I'm sorry.
yes,
I appreciate Sadia's attempt at codifying notice and having an escape valve. I think that it balances the need to recognize both that it's a business and that you're fulfilling a need in a practically monopoly environment, right? It's just very, very hard to relocate as a good tenant. And we hear a lot of stories of of people being relocated, multiple times within 12 months, who are good tenants, who pay their rent and aren't causing damages just because of market pressures. And so just letting the market run its course is what's hurting some people. And so it's, creating some buffers to me makes sense.
I see it as a business, and what I'm having a hard time with is how would I be thinking if there wasn't this housing crisis? Would I be looking at it differently and as a business with making a decision? Because when you're in this spot, when you know that it's urgent and it's a crisis, you're going to look at it from a more emotional standpoint. So I'm having a hard time.
One of the things I should just clarify is about my own position, because I would change 772 if I was, it was just up to me. I would change 772. What 772 does is it looks at all of the reasons that a tenancy could be over, and it treats them differently. One group are within the control of the tenant. It may be, not control is the wrong word. It's the tenant who is the relevant mover here. One is no money, so they don't pay rent. It's the tenant's action. Another is the tenant is violent or otherwise endangering people. 772 kind of has short notice periods in that event. Then it shortens things. Then there are matters that are really up to the landlord. Like I'm the landlord. I want to turn it into a family thing, or I want to renovate it completely and I can't have a tenant there when that happens. Or I am converting it to a condo. Or the tenant is, I'm not contending the tenant is violating the lease, but the lease is over and I just don't want this tenant here anymore for whatever reason. In that case, 772 gives very long notice terms. It's 60 days if you've been there less than 2 years and 90 days if you've been there more. I would add to that two things. This is just me. It's not in 772. I would take something in Saudia's bill and put it in. Saudi has a CPI plus 3% limit. Okay. 772 had a CP, or 8%, whichever. 772 had a limit, but only on sale of the building, because I've heard so much about that problem. I would change that to the landlord upon sale of the building can raise the rent, but they can only raise the rent to reflect their actual costs, including rent, mortgage, that's taxes, etc. The other thing I would do is take from Saudi's bill. Saudi has a relocation requirement. And at first I was thinking, oh, wow, that's a lot to ask. But then I realized that her bill is actually fairly modest. What her bill does is say, under certain circumstances, the landlord has to pay relocation costs up to 1 month's rent, which would mean the landlord could just waive the last month's rent, or if they've already paid it, return it. And it occurred to me that for this class of things that are control of the landlord, I'm not talking about non-payment of rent, violence, or endangering other tenants or any of that. Forget that. But if it's the kind of thing where the landlord's saying, I just want you out, or I know you're paying rent and all that, I just want you out, or I want to use it for my family or want to rehab or whatever, they have to give people a little assistance in relocation up to 1 month. So that, I just want to clarify, although 772 doesn't have all of that in it, I would, it's my view is fair. So Tom, then Joe.
You wait first.
Joe then Tom.
I think we need to remember that the reason we're doing, I'm getting a lot of emails from everybody about how this will be a disaster for this, or this will be a disaster for them. And I need to point out it's already a disaster. And what we're endeavoring to do is ask pretty much everybody to raise the bar for their own responsibility. It does have the longer notice periods when it is a decision the landlord's making that is separate from the quality of the tenant and is under their control. It does shorten the time periods when it is something that the tenant is causing. There's the reason we're doing this is because the disaster is impacting people who do not have an apartment. We have problem tenants occupying space that there are probably 2 other tenants that need desperately. And we have people, because it's already a disaster, we have people who just don't want to rent. And there are people who need those rental units. And at the moment, because it is a housing crisis, we need to do what we can to influence the market to bring more of those rental units online for the sake of people who do not have a place to get indoors at the moment. It may be that 5 years down the road, the rental, the crisis is over and some other committee can revisit this, but for the moment, I can't envision not addressing it because we need rental units available. Need them available. So I'm willing to craft a legislation that is asking everybody to step up. Because I don't think I've seen yet an email that speaks to both sides of the issue. And that's the problem. We have to, and nobody else is, and there's been time for them. The market has failed to find consensus in and on itself, and everybody's advocating for their group. So we need to be the ones to say, we're redrafting the rules. Here's the game. You play the game, but the rules are changing a little bit because the rules we have are not sufficient to make it work out in a healthy way.
Joe,
I got no direction on which way you're going on that. I mean, but we should,
Right down the middle, nobody's gonna like it, but it's gonna have to work.
all opposed.
you'll withhold. I don't know, Tom, whatever Tom said is causing you to stop talking.
No,
I was still wondering what I said.
I just, I think that's our entire process in general, I hope.
Well, I
Yeah.
just kind of bringing us back to that because we've been really snagged on details.
Right, I wanted
Right,
to,
so on
but
this
this is
detail,
what we're talking about here is sort of a very fundamental cluster of things, which is, and I guess and then I'm gonna ask, Gail and then Debbie. I'm arguing for, admittedly, as I'm down the middle. I don't think, I think we have to allow landlords the ability to non-renew. I don't think we can put in rent control across the board that is based on CPI rather than cost. But I do think we can get at cost, at least for sale of buildings. I don't think we should ask in a situation where the tenant not in control, but is behaving and the landlord for business or other reasons wants to change the tenancy, I think we need to allow that. And in fact, all the bills do. The question is, what can we do for the tenant? And my proposal is what we do for the tenant in that situation is A, give them a lot of notice, and B, give them a little financial help at the end of the lease to help the relocation. That's all I'm saying. Joe, you were going to say, and then 1, 2, 3.
Yeah, I'm not for the relocation if you're just doing it that way. If you're just not renewing the lease. It just feels like a penalty for following a contract. No, maybe penalty is not the right word, but it just feels like I held up my end of this contract and now I owe $1,000. Or I owe $1,400. If I know that that's going to happen and that's how I have to, that's my part of the bargain for holding up contracts. Well, guess what? Now rent just went up $130 for everybody because at the end of your term, when I decide that I'm going with the contract we had and not renewing it, that's my decision. Now I owe X amount of dollars and that's coming out of all of your pockets.
How do you feel about a month's rent for when the non-renewal is not, when it's not based on just, I want to non-renew, but I want to use it for my family or repurpose the unit?
Still not, I mean, it's still the same thing. It's still the end of a contract.
The businessman is gonna count that cost into their overhead potential. It'll be reflected in rent somewhere.
It might have been answered already, but I don't remember. If the landlord decides not to renew, do they have to give 60 days notice
Yes,
to the landlord?
under
to the tenant?
770. They do under existing law and they do under 772.
Okay, so.
Or 90, or 90.
Informed.
It's 30 days if you've been there for less
Oh,
than
wait,
2
and
years.
2 years.
60 days if you've been there for greater than 2 years. For the end of a written agreement.
This is under existing law.
Yes,
Yep.
And my bill, 772 changes it to 60 and 90.
because it goes to 60 and 90 if you don't have a written agreement.
Okay. That's.
And
a month to month.
mine, right, and mine doesn't care whether it's a written agreement or once a month, it's the same. Yeah, 60 or 90.
I would just say that putting that in 90, I think is almost arbitrary. Speaking with the landlord actually at the grocery store yesterday. They work under contract. They have a written rental agreement across the board for everybody. Doesn't matter if it's your first year renting or your 12th year renting. 60 days before the contract is up, they show up with the new contract. You either sign it and admitted, I can't vouch for it, but there never anything wildly different about him. Maybe a small increase here or there, a little something. If you don't sign the contract, the next is your papers, because I work under contract under lease terms. So
That's my question.
Doesn't matter.
Why
He
would
just
it
would show
be
up 90 days
different if
before.
you're there? Well, that's my question is why would there be any difference in time frame whether you're there a year, 5 years, 9 years? Why does that matter?
I think the theory is that the long-term tenant is someone who's been there longer, has more rights. It's sort of like the probation. It's not, instead of just a probationary term, which is, and then I want to get to Saudi, she's got her hand up. A probationary term of 6 months is one thing. This is sort of like the next step. It says the longer you're there, the more rights you have. And that is true in many European countries. They have, the longer you're there, the more notice is required. In some to my knowledge, in European countries, you never have the right to stay forever, but the notice period goes up to like a year, substantially longer. And the only thing I'd say to Joe is, in commercial setting, that amount is just subject to contract negotiation. It can be 90, it can be 120, it's often 6 months. It just depends on the business usually. And also it depends on the power relationship. I mean, you know, if you're a landlord negotiating a lease with Chevy's, and you just sign on the dotted line. If you're negotiating it with, if you're a really powerful, you know,
Post
owner of the
office renting
building.
your building.
Yeah, right, it depends. Saudia,
Thanks. I just want of three things. So one, the clarification of that I just want to make it abundantly clear that this was brought forth by a group of folks who have been experiencing these things and other community advocacy groups, and that's where H440 came from. So I just want to be abundantly clear that it wasn't me advocating for myself, because full disclosure, I actually burned some bridges by changing it the way that I did. So I want to make that abundantly clear. Number one. Number two, is that precisely what Joe was saying when it comes to the notice of what the person who you were just referencing, how they go and give that 60-day, that was my intent. That is what I was trying to convey when I said to give the notice if they don't want to renew the lease. And so that, I mean, maybe the language wasn't right, but that particular point, that is exactly what I was trying to say, in that they can't stay indefinitely. If you don't want to renew the lease, come with the new lease ahead of time and address the issue, just as Joe just stated. That was my intent. Sorry if I did not articulate that correctly. And then the third part is most landlords collect first and security. And so it's not that they have to come out of their pockets per se. They should already have that money, because they should still have that person's first, last, and security in most cases, or at least their security. And we're not talking about damage. I'm not talking about damage. I'm not talking about people who are there for breaking the lease or other situations. I'm talking about people who didn't have a problem, you just don't want them there anymore. In those instances, there should not be a problem as to where they would not get their security deposit back, which in most cases is the cost of 1 month's rent. So I don't see how that I don't see how that would pose a huge barrier to landlords. And I say that and not as a landlord. I'm not a landlord, so I can't speak for them. I am a renter, and I have been evicted multiple times. I have had to move out. I have had to go through these things. And guess what? FYI, storage units require a security deposit too, and first month's rent, just like a rental agreement. Same difference. And so no matter what thing you're going into, you have to do those things. And so I would like to say, I would like to think that my perspective is coming from a sound, clear perspective, because I actually truly want landlords to benefit. I have found housing experiences. I've been renting since I was 16 years old, paying taxes and renting apartments since I was 16. So I hope that we find landlords who continue to be in those situations, right? Who continue to take those chances and rent to people. And if landlords aren't in the business of eviction, then this shouldn't be so scary. We're just putting in precautions to set a healthy balance. And so let's create that healthy balance and put those boundaries and buffers in to protect all parties involved, so we don't have people dying of exposure. We don't have working class Vermonters losing their homes, families and children being displaced. Children cannot learn if they're unhoused and don't know where they're going to sleep, or have to commute 3 towns over to go to school because they're staying in a shelter elsewhere. We're here to help Vermonters. So I'm just saying, let's focus on the language, on what we want to do and how is the best way for us to do that within the parameters of what we can actually accomplish. Sorry for participating again.
under the current, here's what I'm gonna propose. I realize in a way I'm sort of nudging things along without there being total consensus. I know that. Council, I am going to propose that for now in 772 only, you include the notice that I've talked about, you know, the substantial notice for those circumstances. And that you include that you include a cost limitation that is articulate, you know, that it has in it all the kinds of, you know, it says including but not limited to legitimate costs of operation, including but not limited to the usual stuff, just so we can look at that for sale of the building.
If you're selling the building.
Yeah, it's the same thing that 772 now has, but uses CPI +3.
You're saying not sell the building, but raising,
Just sale of the building. If you sell the building, 772 does not have any rent control except for sale of the building. Because that is what I had heard. Remember, I was trying to craft a compromise.
Yeah,
I've
yeah.
heard that the worst situation has been in this rising market, which isn't going away. Landlords just jacking up the rent too much. When they sell the bill, and the new landlord comes in and raises the rent. And I'm saying change the CPI +3 to a cost-based. Okay, and
Cost, we can talk offline, but
Yeah.
cost.
yeah, the cost of operation, including taxes, maintenance, financing, et cetera. Okay, I mean, I just think the committee has to look at that. And the other is, I think we should import the 440. This is not, I think we should import the 440 relocation, but I think we should limit it to situations that are conversion to other uses or renovation, but not raising just the end of the lease. And I think it should be up to 1 month's rent. The 772 does allow at the moment,
it's okay.
772 does allow at the moment in the current draft, it limits the security deposit. I believe it says first, last, and 2 months. It doesn't say just first. It says first and last.
First +2.
It doesn't say last. Can people under existing law just ask for first and last?
You can,
Yeah.
but how I would read it, and I'd have to pull it up, is anything other than first month's rent.
Yeah,
I always think about it.
It's part of the security
You're
deposit.
Paying for the first month, so you know
Yeah.
you're going to pay that. Anything other than that is a security deposit. It doesn't matter what you call it.
okay. All right, okay. So I think that I'd like to see that in a draft, just to see what it looks like with 772, okay?
Security deposit staying as you have it.
Yeah.
I
Yeah,
do have to rest.
yeah. Debbie, quick, and then we got it.
Yes, very quick, because we have units coming off the market, we know that because of our current tenant landlord laws. And I think we have to be aware that I think we should look at a timeline, like maybe 6 weeks for the whole process to end. So when you want to do 14 days here, which is a little over 2 weeks, that means the rest of this process is going to take 4 weeks. So when you keep adding times on, because we want to keep units on, we want to keep landlords in the business. That's my 2 cents.
Okay. We have lost our quorum, I think, or just about. We're now going to adjourn until 1 o'clock, and we can continue this conversation at 1 o'clock. Okay, but I think we've got to keep going until we've covered the issues and can come back and decide where we are, okay? So should we go stay live or?
No.
Okay, so we're adjourned